Matter number 3 is H050498, Tashiana Shevertalova, plaintiff and appellant versus the City of Saratoga, defendant and respondent. If counsel could step forward.
Good morning, Your Honor.
Good morning.
Welcome. Here on behalf of the appellant.
All right, thank you, sir. And you provided a 10-minute opening, 5-minute rebuttal estimate.
Confirming.
All right, thank you very much. And appearing for the City of Saratoga.
Good morning, Your Honor. Jennifer Emmanuel for the City of Saratoga.
Right, and you reserved 15 minutes?
Yes, Your Honor.
All right, thank you very much, Mr. Volkov. You may step forward.
Good morning, Honorable Justice, and may I please the court. This appeal stems from the judgment of dismissal, which in turn came from a ruling on the demurrer without leave to amend. And as such, as we will analyze different turns of this case, has to be kept in mind to be analyzed from the length and the standard of a demurrer, meaning only the pleaded facts and materials properly judicially noticeable should be weighing into the decision on the demurrer. The appellant in this case argues that that standard wasn't followed in the trial court. The underlying factual situation is not complicated. The lady, Ms. Shevertalova, flipped on the sidewalk in August 2018. That intersection happened to be right in the immediate proximity of the city hall of the city of Montserrat and abutting the highway maintained by Caltrans as it appeared to be. Ms. Shevertalova made 2 government claims, one to Caltrans, one to Montserrat. Those were denied, and she filed her original complaint as per. The discovery ensued. During that discovery, in the period between October and December 2019, first the identity of City of Saratoga got identified, and by December 2019, the involvement in the main construction and maintenance of that sidewalk by the City of Saratoga was identified. Following that date, in March 2020, Ms. Shevertalova made her claim in 3 ways. 2 through the city, the formal ways, one hanging her form in person, and one by submitting through the online form, and one informal through the by email to Saratoga's council, who was known at that time because the City of Saratoga was already part of the action, just because the Caltrans standard, the defense to Saratoga, and Montserrat was also considering that, and in fact later countersued Saratoga. Those other claims by now have been resolved or dismissed, so they're not part of this appeal. So we argue generally 2 points on the demurrer. One is that the court made factual findings such as that the plaintiff wasn't diligent enough, neither in finding the involvement of Saratoga, nor in following up to the denial letter, made a factual finding that the accrual of injury as to relates to Saratoga happened on the date of the injury, which is of course a material point because the date of accrual factors into the applicable government code as in its language, and also found in the ruling on the third amendment complaint, the court made a finding that the plaintiff was well aware of the statutes of limitations on unknown to me basis. However, that finding was later cited in the follow-up demurrer fourth amendment complaint, and of course that's the one which led to sustaining of the demurrer and this appeal. There were extraneous materials considered in the opposition, in the support to the City of Saratoga's demurrer. There were submitted several exhibits fashioned as a request for judicial notice, from Exhibit 7 to Exhibit 14, which were the results of the online searches and some web-published PowerPoint presentations. And they were supported by a declaration of Saratoga's council, showing how she made the search, and that's the results made into the request for judicial notice. In the order, the court in its footnote 1 said that they are not considering the declaration. However, the very next page, the top part, the court says, and by the way, 3 of the links did not work, so the court will not consider out of this scope Exhibits 11, Exhibit 12, and Exhibit 14.
Mr. Volkov, I'm going to interrupt you for a minute, and I'm not meaning to be rude, but I just want to ask this question. So if I'm understanding what you're talking about right now, please correct me if I'm wrong, what you seem to be saying is the trial court erred because it considered matters that it shouldn't have, and basically engaged in fact-finding, that it shouldn't have in the process of ruling on the demurrer. Am I right?
So far, that's the argument I made in my oral presentation,
Right.
but there is one more to make.
Oh, no, I know. I think I'm probably going to nudge you in that direction, because
Understood.
isn't it the fact, unless my colleagues feel otherwise, but isn't it the fact that what we do here is a de novo review? So even if the court considered something that they shouldn't have, or did something that they shouldn't have in the course of reviewing the case for a demurrer, we look at it all afresh. Am I right?
Correct, Your Honor.
Okay, so maybe the second argument is the one that would be of more assistance to us, unless one of my colleagues wishes to intervene. All right, thank you.
Going to the second argument is what my client considered should have been considered by the court. One is the propriety of Saratoga's entering the case under the DOE substitution under the section CCP 474. The court, in its order, cited the Benson case only for ruling away on the delayed discovery. However, the Benson case holding says it's either or. If you don't know the involvement of unknown wrongdoer, but you know someone, sue under the DOE, take discovery, and then substitute the name. And that's exactly what happened in this case. As the record shows, we learned about Saratoga's involvement through discovery and went on to substitute. The second point which the court abstained to rule on, and I believe that's abstention prejudicial, is on the waiver. The letter, the subject of this dispute, the denial letter from the city, was silent on the late claim disclosure which is required under 911.3 subsection A. And the subsection B says if that is not there, the claim to lateness of the government claim is waived.
But let me make sure I have the dates here in mind correctly. And I believe the claims to Saratoga were made in March of 2020.
That's correct.
And the date of injury was August of 2018.
Injury, yes.
So as far as Saratoga is concerned, if they receive in 2020 a claim about an injury in 2018, why, since that's well beyond 1 year past the date of injury, why would the city even think it relevant or germane to reject that based on untimeliness and assert that particular thing, including the waiver language?
Well, because the statute is very clear. It goes from accrual. It doesn't go from the injury. And if the city believes it's late, that's exactly where 911.3 applies. To argue that, hey, we thought in our office internally that it's too late to begin with, and so we don't want to inform you that the claim is late, contradicts the actual language of the denial, because instead of it, they included the claim under 993, saying, hey, you can sue us. We denied it as a matter of law. You can sue us within 6 months. And that's the opposite of what could have been done. So 9.3 is very clear. The language, the subsection A says, here's the substantially the language which should be there, shall be there, and if it's not there, the late claim is waived.
Well, do you dispute what the city raises and what amici emphasize also, that a late claim subject to the late claim process under the statute really is something that's submitted in that 6 to 12 month window.
From the accrual.
Okay, from accrual, but do you agree, for purposes of statutory interpretation, that really that notice provision and the late claim information to a potential claimant has to do with, say, a personal injury claimant who submits something at 7 months, still has 5 months remaining in the 1 year, but it's past the 6 months for personal injury. So do you agree with that being the purpose and interpretation of that government code section?
Yes, but the government code section clearly says accrual. In every section where it's been brought up, it is never said from the date of injury except on the 2-year rule when there is no response made. And that's one of the claims made here. At the time when we made our ex parte to add Saratoga as a DOE defendant, there was no letter yet received. The letter came in that month after the ex parte application was made. So why I'm highlighting it, it's not just the facts pleaded in the complaint. We have a declaration under penalty of perjury of my co-counsel who said, I'm making this, I think it was January 12, 2021, and as of this date, no denial was received. And in their reply brief, the Saratoga concedes that with the COVID extension, the time to make it was up to January 28, and we made it on January 13, the applications. And that's the only time where the injury factors it. Everything else is from the accrual. We cited numerous decisions saying the accrual comes when the last element comes into the picture. The last element is the knowing of the negligent cause that wrongdoer did, not even the identity. We learned about Saratoga's identity in October, but about the involvement we learned by December of 2019, that they're responsible for the sidewalk. That's where the accrual happened. So our position that the claim was not late. If the city of Saratoga decides that it's late, they have to include this language. There are 2 cases very focused and on point. One, it's a published opinion, but at the time I did my reply brief, it was still just the Westlaw link. Now it's available. It's AS versus Panday, 94 Caleb 5th, 1091, and the pinpoint is 1099. It says it's a duty of the governmental entity to inform. And then there is the Andrews case, which is on page 39 of my opening brief, which analyzes a very similar situation just with the section 913, where the other required disclosure wasn't included. The court said substantial compliance means complying with every element. You didn't include the disclosure, you waive your defense on that. And there is what's happening here, only instead of 913, we have it under 911.3.
Let me take you back to this idea of the accrual of the cause of action, though. And help me understand how the identity of a responsible party is an element of the cause of action.
Identity is not. The involvement of the responsible party is.
So help me understand what you are distinguishing.
Under a holding of Burnson, the Shevertalova sued DOE defendants and alleged that they're involved in her injury, including DOE 1. Starting first amended a complaint, the cause of action for the government responsibility was already pleaded against all defendants, including DOE 1. Discovery took place. Saratoga was first identified. The identity happened. That's not yet the element. But then we found the contractual obligations that Saratoga is the lead entity for this sidewalk, construction and maintenance and perpetuity, meaning while it still exists. This knowledge of their contribution to both construction and maintenance, because that's how the injury happened. That was only discovered in December 2019. And again, we're in the demurrer field. This is how it was pleaded. It should be deemed true. There is not a single judicially noticeable material that says otherwise. And to even go a step further, those web materials, even if we accept them as judicially noticeable, they do not show a responsibility of Saratoga for Monte Serena's sidewalk. And from the standard of a reasonable, prudent person, it wasn't on the border with Saratoga, it was up front of the Monte Serena City Hall. So it wasn't obvious in any particular way. However, what a prudent person should have done, how diligent enough that person should have been, that's a question of fact. Several cases cited in my open and reply brief says only if there is one conclusion, then it could be decided on a demurrer stage. But if it leads to several conclusions, then it's a question of fact not applicable to the demurrer.
So I want to make certain that I'm understanding something, and I might be oversimplifying it, but what I'm hearing you say is that when you filed the complaint, essentially you did include all of the elements, but the one thing that was missing in terms of Saratoga was identity.
The identity was missing because at that time we had
You
no
didn't know.
idea about Saratoga's involvement. And there is an important distinction. As of the First Amendment complaint, the injury was stated, the dates, but there was no cause of action as it should be for the government entity responsibility. That came in the First Amendment complaint, which was still within time. I believe it was August 2019. So starting from the First Amendment complaint, that's the cause of action which remained. It was always pleaded against known defendants and or defendants. Once we learned about, not just identity, which is not an element, but involvement of Saratoga, the application, the claim was made, and then the application was made while there was still no denial letter. Then the denial letter came, and here we are. There is also, the record indicates that the city of Saratoga conceded to the jurisdiction. It was they did not oppose our application to substitution. They reserved the right to demur, but they didn't fight the jurisdiction of the court.
I'm going to stop you there because I know you want a little time for rebuttal. I'm going to reduce it a bit because you went substantially over in response to our questions, I might add, but nonetheless. And let's hear from the City of Saratoga's counsel.
Thank you, Your Honors. May it please the court. There's been some commingling of concepts throughout the briefing and oral argument today regarding the concepts of the two different statute of limitations that are involved. There's a statute of limitations to submit a government claim, which involves a 6-month to 1 year accrual. And then there's the statute of limitations to file a lawsuit against a public entity. And the government claim statute is when we discuss the delayed discovery issue and the accrual. And the statute of limitations to file a lawsuit is when the relation back doctrine comes in. And all of that has been commingled throughout the arguments, which makes it all quite confusing in my opinion. It's pretty much undisputed, I would say, by the papers and based on the trial court's ruling. If the accrual date is considered the date of injury, the appellant did not submit a government claim form in time, not within 6 months, not within 1 year.
To Saratoga.
To Saratoga,
Right.
I apologize, yes. And so it would be untimely. And so the issue then is, was there delayed discovery to warrant a late claim in this case? Or to justify the October 11th, 2019 delayed discovery, which is what the allegation is. There's a lot of, in the briefing, there's a lot of use of the word evidence, but we're at the demur stage at this point. And so really it comes down to what is alleged in the complaint. And what is alleged in the complaint is, in what the trial court found, was appellant did not allege any due diligence between August 2nd, 2018 and August 2nd, 2019, the first year after the date of injury, in which she did anything to discover who Saratoga, or Saratoga's involvement, not responsibility, as appellant just explained. Now, admittedly, Saratoga, it was not within, the accident did not occur within the city of Saratoga. However, appellant knew early on that this accident occurred at a specific location across the street from the city of Monte Sereno. And the papers, the record shows that the appellant conducted a site inspection with an expert. What didn't happen was walking into city of Monte Sereno and doing a public record search and asking for all records pertaining to that corner. Didn't need to know the name of the project, didn't need to know who was involved, just needed all records pertaining to that corner. And the records would have been produced within 10 days under the Public Records Act. which would have-
Excuse me, just one moment, Ms.
Yes.
Emmanuel. So I appreciate the distinction that you're making between the allegations of the pleading and the references to evidence, but I, to the extent that one of the issues that the appellant has raised is whether the trial court on some level made factual findings here, albeit in a challenge to the pleadings, about the not just the adequacy of the diligence alleged, but about an actual lack of diligence. I just want to make sure that we're not losing sight of that in the course of this particular argument, because this was an order sustaining the demur without leave to amend. If we accept that the Fourth Amendment complaint did not, in fact, adequately allege reasonable diligence, and if we were to conclude that the delayed discovery rule applies, then would we necessarily need to reverse the without leave to amend aspect of the trial court's ruling to give the plaintiff the opportunity to amend?
I'm not sure if you do find there's delayed discovery, would you need to necessarily give?
If
leave to
we
amend?
find that the delayed discovery rule applies, and if we were to nonetheless agree with you that the Fourth Amendment complaint did not adequately plead diligence in the discovery of the city of Saratoga's involvement, identity, et cetera, to the extent that the trial court sustained the demur without leave to amend, would we need to reverse?
I do not believe that the appellant has indicated to the court how it could amend the complaint to remedy, if I'm understanding the court's question. There's been no explanation as to what in the they've already had one chance to from the Third Amendment complaint to the Fourth Amendment complaint to amend and add amendments. They've had an opportunity to explain what they did between August, or between any of those dates, frankly, between the date of injury and the claim to Saratoga. In all of the papers and on the record, they haven't indicated to the court what could be done to amend so that to make a proper allegation. What's still missing from the Fourth Amendment complaint and from the papers, frankly, is what was actually done. What
Well, exactly. Can't that be pled in a Fifth Amendment to the complaint, such that there is a greater or satisfactory demonstration of due diligence?
But I believe they were to explain to the court how that could be done. That hasn't been done, from what I saw in the records. It could be pled. I'm not sure how that could be pled. I don't want to cast aspersions. Based on what I've seen, the papers show that the plaintiff or appellant knew of Saratoga's identity, or claiming to know, as of October 11th, 2019. They also made a government claim to the city of Monte Sereno as early as October of 2018. They, at that point, knew that public entities were involved. They knew the Highway 9 Safety Improvement Project was involved. It's a multi-jurisdictional project. It's not a secret. It's been going on since 2010 by the record reflects that. And it was plain appellant's obligation to at least conduct some reasonable inquiry into other entities that could be involved. They were on notice that public entities were involved.
But I guess the question is, what if she did, and it hasn't been made clear to the court? Is that something that would be properly within the scope of an amended, if granted leave to amend?
I believe that's at the discretion of the court. I mean, I personally don't think so. I believe that the trial court gave them an opportunity. They've been given an opportunity. If,
Well, being given opportunities, I mean, we have cases here where there are
Yeah,
more than
agreed.
four
I understand.
amended complaints. And so being given an opportunity versus really our ability to conclude and the trial court's ability to conclude reasonably that there is nothing that can be done to salvage the complaint, I think are two different things.
it's hard for me to say. I believe that the trial court gave appellants opportunity to amend, gave them in their tentative ruling on the third amended complaint direction as to what needed to be included to plead their due diligence, and although they added 17 paragraphs of what they claimed to be due diligence, none of that alleged due diligence occurred during the relevant time period.
So are you suggesting that it's within the trial court's discretion to effectively become impatient with a plaintiff's amendment attempts, as opposed to determining, when asked for leave to amend, there is nothing you can do to fix this?
I'm sorry, did you say impatient?
Yes.
Is that what I heard?
Yes, I mean, you seem to be suggesting by your repeated references to the plaintiff having had opportunities to amend, that at some point, if she's not successful, then the trial court has discretion to say, you know, I've given you enough chances and you haven't done it yet, as opposed to the trial court coming to the conclusion, no matter what you do under these facts, there's nothing you can do to make this a viable complaint.
I believe the trial court did make that determination, that there was nothing else that could be pled. That's my understanding of the court's order, that they had given plaintiff that opportunity and that there was nothing else that could be pled to overcome the deficiencies, especially given the fact that the court had made the determination that the court had made the determination that plaintiff had their accrual date was the date of loss, so and that the claim statute had been violated.
So if I could just follow up then, when the trial court says in its order, plaintiff was not diligent in obtaining facts that would identify defendant Saratoga as a party, you're saying that that's not a factual finding, even though it's seems to be framed as one. It's a determination that after 4 amendments, and a big hint in the tentative ruling on the third amended, on the demur to the third amended, that's less of a factual finding than it's just, if there were anything there, you'd have come up with it by now.
Well, in a sense, yes. I mean, I don't know that, I mean, I think that they were given their opportunities. I don't know how, I believe at some point it's a use of discretion standard, I believe. And I think at some point, I don't know how many amendments a court will allow before they finally make the determination that they're not gonna allow further amendments. Does that answer your question?
Yes.
So, I'm not sure if you want me to keep going on about delayed discovery. It's been briefed pretty thoroughly in the papers, and our Saratoga's position is there was plenty of accessible records, publicly available to appellant to identify Saratoga, and a lot of argument is about information that was about Saratoga being involved in the litigation. None of that is evidence in really, they really weren't. They had just started to become involved, and the scope of those tenders is not on the record as to what they knew about the litigation or the substance. As far as the waiver issue, the concept of the 911.3 waiver in Saratoga's position that the statute itself was not triggered in this situation, based on the claim, and again, this is explained pretty thoroughly in all of the papers, but at least Saratoga's position, that if the remedy itself that's contained within the statute is not available, including the language in a rejection letter advising a claimant that they can seek late claim relief, just doesn't seem within the scope of the meaning of the statute. The statute itself, I believe this is within the language of the statute. The statute itself provides that if a late claim application is not included with the claim, then the public entity is to include this language so that the claimant knows what its next remedy is, and that would be the possibility of filing a late claim application. That was not a remedy that was available in this circumstance.
So I take your point as far as the utility of the warning that's contemplated by 911.3A and the notice requirement. I guess just as a matter of construing the statute, though, subdivision B of the statute spells out the exception to the required notice in A. And you know, because that doesn't include the circumstance that you're talking about where no notice would help, because we're that far past the accrual date. Why isn't that dispositive?
The statute?
Why isn't the exception in B, in subdivision B, why isn't that the only exception? Where do we get the authority to expand B to allow the government entity to decide for itself a subdivision A notice isn't going to help this claimant? It's not just late, it's too late. Wouldn't the legislature have said that?
I don't think it's an expansion. I would argue that the statute itself isn't even triggered yet. That if the remedy, the statute itself is alerting a claimant to a remedy, and if that remedy is not available, my argument is that statute's not triggered.
But the statute lays out what its trigger is, doesn't it, in subdivision A? The trigger is when a claim that is required by 911.2 to be presented not later than 6 months is presented after such time without a 911.4 application. That's your trigger, isn't it? That's the only trigger that I see in the statute.
Well, in my reading of without a late claim application, my reading of that though is that the purpose of it is for purposes of filing a late application. And if that remedy is not available to the applicant or to the claimant, if sending a letter back, a rejection letter to a claimant and alerting them that their next step is to file a late claim, when that late claim would have to be denied, and meanwhile their statute of limitations for filing a lawsuit is running, or should be running, doesn't seem
logical.
It doesn't seem logical.
Right.
Thank you.
So let's say I agree with you that it doesn't seem logical, and that you know, if there's no possibility for relief under 911.4, what good is the notice? Let's say we agree with you on that. That's just not in the statute. there's nothing in A that says A doesn't apply if you're not eligible for 9/11/4 because you're past the 1-year mark. We have subdivision B, which lays out an exception to the notice requirement. And that express exception doesn't include the situation that you're talking about, as logical as it might be. And so my question is, as a matter of statutory interpretation, even if everybody in this room agrees with you as far as the logic, do we get to do that work for the legislature?
Well, I think I think there's a difference between doing the work for the legislature and actually interpreting the statute as it's written.
But we've
And-
got the plain language of the statute. The plain language of the statute doesn't seem to help you.
Well,
Logic does.
logic does, but I think if we ask the question, does this statute apply to this or does the statute apply to this situation, then we are applying it in hindsight. If we ask whether the statute is triggered by this event, then I think the statute applies, and we can say, no, this statute is not triggered by this event, because after the 1-year mark, the court has no jurisdiction to even hear a petition for a rejection of a late claim application. And so this statute seems moot, which I think is what the trial court, if I could be so bold, meant in its the 3 or 4 words that it said in the ruling. I mean, I've read that about 100 times trying to understand what it meant in that one line, and that's the conclusion I came to, is that what it was saying was that the statute was not even triggered yet. Not that it didn't apply in hindsight, but that it wasn't triggered yet because the 1-year statute had already expired. And so I think we don't even have to get to changing the legislature's intent, because the statute itself we're not asking whether it applies to this situation because it hasn't been triggered yet.
If there are not other questions from my colleagues, I'm actually going to stop you because we've let you go over
Okay, yeah,
significantly.
felt like that was a long time. Okay, thank
Right.
you.
Yes, thank you very
Your
much. We
Honors.
had a lot of questions. Interesting case. Come on up.
Thank you, Honors.
Thank you.
I have just a few points and I'll go in reverse. So on the question of the statute, the letter, while omitting 9.1.3, did include the mentioning of 9.1.3, saying go ahead and file your lawsuit, which leads to only one reasonable interpretation, unless it's just a neglect and omission of the other disclaimers, that as of the time the city of Saratoga did deem it as a timely made claim. And that's where 9.13 applies, and that's expressly stated in the letter. And I'll, if I may concur with Justice Lee, 911.3a clearly says, it's expressly in the statute, applies after the time for 911.2, that takes time, and without 911.4. And that's the situation here. The policy, as it was mentioned and is cited in my briefs, the public policy of interpreting government claim statute was not interpreted to enlarge the ways or lessening the duties of the city or enlarging the cases where they can avoid liability for the claim. So that's taken into the effect of interpreting that language. So and that's how the statute of waiver was triggered. Now going back to the delayed discovery and pleading of due diligence. The justices on its face will see that it's named fourth amended complaint. However, on the issue of due diligence, that was the first amendment, and it wasn't taken lightly.
I'm sorry, on the issue of what? It wasn't the
Due
first?
diligence and delayed
Okay.
discovery. It was just the first amendment from third to fourth. I was the pleader, and the instruction of the court was not taken lightly. As my colleague mentioned, not just 17 paragraphs were added just on that issue. There were several exhibits. It's mentioned in the record. I don't remember how many. I think it was 14. So it describes the chronology. It describes the attempts. It describes the efforts through discovery and outside of discovery. There was a professional hired, the expert on whose report Ms. Shevertalova relied, and I cited case in a appellant brief, seeing that as a reasonable diligence. The materials are cited in the exhibits, and in the big picture, if we take all of these materials, and even what Saratoga's counsel under her declaration request for judicial notice submitted to, none of it, publicly available, shows responsibility of Saratoga for the subject sidewalk. The
Maybe
only
not those things, but let me ask you this, because I'm looking at the original complaint here, and this is cited, I believe, in the respondent's brief. I'm looking at page 11 of the appendix, the original complaint, and says, referring to Monte Sereno Hall or City Hall, in front of that location was a warning road pad installed on the sidewalk of that intersection during the Highway 9 Safety Improvement Project, done by Monte Sereno and in conjunction with the California Department of Transportation. So from the outset, it was known that this wasn't merely a municipal little sidewalk project, Monte Sereno, and the claims against, or claims put to Caltrans bear this out as well, that there was clearly awareness. This is part of this larger consortium project. So doesn't that undermine these claims of due diligence?
It doesn't undermine, it actually explains it. That's why the expert was hired. That's why his reports included in exhibits to the Fourth Amendment complaint. The city cited it in the reply brief as 6 entities. It was 7 entities. It just not happened to be the Saratoga's involvement for this portion, or the information that the Saratoga is the lead agency overseeing every sidewalk. And that's the involvement with the injury. For example, there are 3 cities on this project. There is also city of Los Gatos. They are uniformly cited 3 in those web materials. We're not suing city of Los Gatos. Why? There is not a molecule of evidence that Los Gatos was in any way involved in Monte Sereno sidewalks. Each one operates within its borders, and that's what material shows. And the material, the contract and the permit materials showing responsibility of Saratoga over Monte Sereno sidewalk, they were only shown in discovery, and it is a material point that through all the searches, these 2 documents, the permit requirements and the contract, they did not show up. It would be a different story if the Saratoga will say, look, I'm typing in what they did in public search, and the contract shows up, and it says expressly Saratoga is responsible. That did not happen, even with the Saratoga's counsel knowing what to search for, because the search already included the word Saratoga in it. Even with that focused, kind of predetermined search, it didn't show up. So the only question left, and I'm hearing it on the argument, why did Ms. Shevertalova didn't do the public record search? But that's a question which was addressed in another case, that it's not always a reasonably prudent person is required for her element of diligence to request a public record. She instead relied on a professional expert's report, which she hired as part of her diligence. She did it timely. The report showed up. It did not get Saratoga's involvement. All of it is pleaded in the Fourth Amendment complaint, should be accepted as true. I'm hearing from the justices that what if it's not enough amended, we will be, of course, glad to amend, but just before we go into the amendment, since it's a de novo review, it's not just 17 paragraphs. Each statement there is supported with an exhibit. And then we have the other records. We technically have 2 declarations. One is a declaration of my co-counsel when she applied ex parte, which says, as of that time, January 12th, no denial letter yet received, and we don't have any contradiction to that. And a declaration of Ms. Emanuel, which says, look, I can go online and search for Saratoga, and here's a few exhibits, pop-up search results and web presentations. Those materials also don't show Saratoga's responsibility for the sidewalk, in fact. So it's not just an average Joe, reasonable, prudent person standard. It's even with the knowing what you need to find, you cannot find it. So That's my answer to this. So it will be at best a question of fact, not a demurrable question of standard of conduct to decide as a matter of law, which requires that no other interpretation of reasonability of conduct could apply.
Right, I'm going to stop you there unless there are questions from council. Excuse me, from my colleagues, not from council. You don't get to ask questions. Thank you very much for being here. This matter is under submission. You'll receive a written opinion within 90 days. We really appreciate your input today. Thank you very much from both sides. Very interesting. And counsel, if I could also just mention, the court very much appreciates in this day and age the signs of collegiality between colleagues opposite. Thank you very much. All right, the final case on calendar this morning is H05